Hi, good morning. Oftentimes it feels as if I've just finished my SJD and all of a sudden I find myself to be one of the veterans in the room. And that might explain, not necessarily justify my old style, which means no machine learning technique and no computation. So sorry for that. All right. So this conference is dedicated to addressing the question of whether and how the law can promote cooperation in a diverse society. This question is very timely. The political framework of the modern age is characterized by deep diversity, and at the same time, modern society is becoming ever more judicialized. This juxtaposition of these 2 points makes the subject of this conference extremely relevant. In my presentation today, I will not analyze the full scope of this question, but rather will focus on my specific area of expertise, constitutions and courts that consider constitutional questions. I will seek to examine whether and how a constitution and a constitutional court can bridge conflicts, quell rivalries, and promote stability and prosperity. Furthermore, it is commonplace to divide the elements of constitutions into 2 categories, the structural portion and the value portion. I will be dealing solely with the latter. My discussion will be general, but in order to illustrate my arguments, I will use examples from the Israeli context. First, I will focus on constitutions. Then I will attempt to ascertain the constitutional court's expected contribution to society. And finally, I will conclude by laying out my tentative conclusions. Well, so in order to analyze whether and how a constitution can contribute to creating cooperation and prosperity in diverse societies, we must first analyze what the role of the constitution is and how it operates. Elsewhere, I have proposed 3 possible roles: protecting rights, deepening the discourse about value dilemmas, and quelling disputes. The first rationale, commonly accepted around the world, views the Constitutional Bill of Rights as a tool meant to protect citizens, placing the Constitution above the outcome of regular political play, fortifying it against easy modification, and enforcing it by a court that is not part of the political arena are supposed to afford such protection. If the Constitution does indeed work that way, on the face of things, we have a mechanism that is likely to reinforce cooperation as it affords minority groups an additional measure of representation and protection for their interests, a fact that should ally their fears and encourage their willingness to cooperate with the majority. Furthermore, there are those who believe that such a course of action will unify the various groups around an agreed upon set of values and blur the differences between them. However, it is not clear that this is in fact the case for 2 main reasons. First, and contrary to commonly held belief, the Standard Bill of Rights is not based on a neutral position, but rather on a particular worldview that frequently clashes with the worldview of various minority groups. Furthermore, even where there is no dispute regarding the content of a common Bill of Rights, there is still dispute regarding the application of the rights to concrete cases. Adoption of a constitution of the kind described above is not a mechanism that bridges disputes and divisions. Rather, it transfers the adjudication of disputes from the political system to the courts. The positions held by judges are based, as we know, to a great extent on their individual worldviews. Assuming that the makeup of the court reflects the balance of power in society, the Constitution interpreted by the court serves as a tool to entrench the majority's views. For that reason, we are likely to find that the Constitution is not a tool for mediation and stability, but rather a catalyst for polarization and deepening disagreements. Imagine, for example, the feelings of the ultra-Orthodox minority in Israel in the face of a court decision forcing ultra-Orthodox broadcasters to put women on the air or prohibiting gender separation on public transportation and at various cultural events and performances, all in the name of a Constitutional Bill of Rights. Second, and continuing from the previous point, a constitution that is enforced by the courts is designed for determinative adjudication. Use of such decision-making mechanism greatly reduces the ability to reach and preserve compromises that are obtained through political negotiation, compromises that are one of the most efficient tools by which to stabilize fractured societies. A constitution that is enforced by the courts prevents the preservation of compromises because of the possibility that the court will intervene and overturn them. Consider, for example, the issue of conscription of yeshiva students, which has threatened governmental stability in Israel for more than a decade because of the repeated judicial rejection of political compromises that have been reached on this issue. The possibility that compromises will be overturned on constitutional grounds not only weakens the chances of preserving compromises reached between rival groups, but also the likelihood of reaching them in the first place. Reaching a compromise is conditioned, among other things, on the existence of trust between the parties. Bringing the Constitution into the game erodes the chances of establishing mutual trust. Each of the parties to the negotiation is likely to suspect that the other side will attempt to use the Constitution in order to avoid its obligation to honor the compromises, and thus will be wary of fettering itself to an agreement. Under the second rationale, the Constitution is not meant to ensure a particular value outcome. Rather, it is meant to incentivize the political system to examine value dilemmas in depth before making a decision. I will not prolong my description of this rationale for constitutions, which I have expanded upon elsewhere. I will only emphasize 2 points. First, a constitution that aims to reach such an objective does not adjudicate dilemmas. Rather, it only provides the foundational building blocks. The end result of the integration of these building blocks is shaped by public discourse. Second, and further to the previous point, in a constitutional model based on this rationale, the court voices its opinion, but the legislature has the last word. As I have explained elsewhere, this is, in my view, the rationale that serves as the basis for the constitutional model that has been adopted in the last several decades in some of the British Commonwealth states. This model has positive potential in that it enhances political discourse on important issues. It is also likely to help promote cooperation between rival groups, the subject of our discussion, as open and in-depth discourse is likely to contribute to creating mutual trust and alleviating animosity and suspicion. Think about the current prevailing approach that encourages people experiences crises in their interpersonal relationships to air out their feelings and hash out their disagreements and not bury them deep down inside. There is much wisdom in this insight. Nevertheless, there is room to qualify it. As anyone who has been involved in a significant interpersonal relationship knows, there are disagreements that, where dragging out the dialogue does not contribute to their resolution. This is exactly the reason why in our various relationships there are matters that we purposely avoid raising for discussion. And from the micro to the macro, in a society that is not simply diverse, but rather is characterized by deep disagreement and division, encouraging discourse is likely to turn out to be a Pyrrhic victory. Therefore, it is doubtful whether a constitution as incentive for discourse is suitable to a divided society. This is exactly where a third rationale for the role of a constitution comes in. According to this rationale, the role of the Constitution is to remove disputed matters from the public agenda with the goal of stabilizing the system and preventing the deepening of the rifts dividing the public. In the literature, this approach is called the gag rule technique. The goal of gagging can be obtained in one of 2 main ways. One way is to take away disputed issues from the public governmental arena and privatizing them. An example of this course of action proposed in the literature is the separation of church and state, which has been adopted by a number of countries. A second way to use the Constitution as a tool to silence divisive disputes is to fix in the Constitution a detailed arrangement of matters that are at the heart of these disputes. The supremacy of the Constitution and its rigidity should make it difficult for parties to a dispute to change the detailed compromise that has been fixed in the Constitution, and assuming that we are dealing with rational players, this would also dampen their motivation to invest their energy in an attempt to bring about such a change. The need for a detailed arrangement is intended to prevent differing interpretations of its content. Lack of specificity would enable a court to relatively easily deviate from the parties' agreement, which would deepen the rift instead of bridging it. In the past, I believe that constitutional codification of detailed accords in disputed matters could serve as an effective means of removing such issues from the public agenda and thus assist in quelling divisive disputes. Today, I have a far greater doubts as to the likelihood of success of this strategy of quelling disputes, a doubt that has primarily arisen from several constitutional developments in the last several years in Israel as well as in a number of other countries. I'm referring to the court's alacrity in intervening in constitutional components whose clear purpose was to prevent the court's intervention in the relevant issue or remedy previous judicial intervention in that issue. While for purposes of such intervention, the Israeli Supreme Court certainly uses the tool of interpretation, it has recently added to its arsenal two more doctrines: the abuse of the constitutional tool and the unconstitutional constitutional amendment, whose application allows it to remove problematic text from the Constitution that cannot be neutralized through interpretation. All right, let me move now to the role of the Constitutional Court. The literature about divided societies emphasizes the usefulness of establishing unifying institutions, such as the institution of the presidency in parliamentary democracies. On the face of things, a constitutional court could also serve as a unifying entity, being an impartial institution above the people and detached from regular politics. This is all generally correct, but it is less clear with respect to a constitutional court where the Constitution also includes a Bill of Rights. In his canonical article from the early 1970s, former Israeli Supreme Court Justice Moshe Landau presented his position on whether it is advisable to establish a constitution in Israel. Landau supported adopting the structural portion of the constitution, but expressed opposition, even harsh opposition, to adopting a constitutional Bill of Rights. One of Landau's grounds for his position is particularly relevant to our topic. Landau explained that given the open language of the Constitution, any constitutional adjudication in matters of value would necessarily be based on the deciding justice's worldview. Landau argued that the inevitable result of such a course of action would be severe harm to the neutral image of the court, which would consequently damage its status. Sadly, Landau's prophecy turned out to be accurate. On the eve of the constitutional revolution, the Israeli Supreme Court enjoyed a very high level of public trust. However, once the court declared the constitutional revolution and began to intervene in the Knesset's legislation, this trust began to erode to a point that today the majority of the Israeli public does not put faith in the Supreme Court. In a recently published study, authors Aaron Garber and Yonatan Givati point to the connection between the constitutional revolution and the drop in the public's faith in the court and refute alternative explanations for this decrease in trust. The fact that a connection exists between the court's intervention in disputes over values and the decrease in the level of trust in the court shared by the public at large is not unique to Israel. Rather, it is supported by comparative empirical studies as well. For example, a recently published study based on data from 15 countries that adopted the concentrated model of judicial review examined the effect of a constitutional court's activities on the level of trust that the public places in the legal system. Specifically, it examined the effect on the perception of the court as a neutral and fair. The study's conclusion is that a constitutional court activities weaken the level of trust that the public places in the legal system. Let me conclude. Since the end of the Second World War, many countries have adopted constitutions that include Bill of Rights that is enforced by the courts. That move rested on the assumption that it would help strengthen and stabilize democracy based on liberal foundations. The success of the constitutional model in fulfilling the purpose for which it was created depends, among other things, on the measure of trust that the public places in the court. If the arguments and factual data which I presented are persuasive and founded, and judicial intervention in value disputes in the name of the Constitution indeed damages the public's trust in the court, then the adoption of such model is likely to do more harm than good. This conclusion is certainly correct if we adopt the common model of an abstract constitution enforced by the courts. But in my assessment, it also makes sense even if we adopt the model that has been adopted in some of the countries in the British Commonwealth, which gives the final word to the legislature, and even if the constitution that is adopted is not worded generally or in the abstract, but rather goes into details. All right, I can return some of the, so I'm not punctual, I will finish.